Hello, everyone. This is Tom Fox back for another episode. And I'm absolutely thrilled today to have back with Kenyen Brown. Kenyen, first of all, welcome back to the podcast.
Thank you. It's a pleasure to be here.
Kenyen, since our last time to visit, you have changed firms. So I was wondering if you'd tell us about your new firm and more importantly, this new role that you have, or perhaps are even carving out for yourself.
No, I appreciate it. So I've switched over to Thompson Coburn, which is a Midwest-based firm, but they have offices nationally in Los Angeles and Dallas, Chicago, New York City. So different places across the country serving a different clientele, still full service, but just a better platform for me personally, although I'm grateful for the prior opportunity I had as well. And in terms of the new role, not necessarily a new role. Previously, I'd served as a U.S. attorney, an assistant U.S. attorney, and also an investigator and a counsel for the Senate Ethics Committee in Washington, D.C., as well as the House of Representatives, where I was a chief counsel for the House Ethics Committee. So investigations are kind of in my blood, so to speak. And while I was the U.S. attorney for the Southern District of Alabama, I served on the Attorney General's Advisory Committee for law enforcement coordinating committee issues and victim witness issues, where I was actually the chair. And in that role, I got to really see the best practices for police community engagement, policing policies. So I've always had a passion in that area. And I was fortunate enough to be asked by the city of Mobile to do an investigation of the Mobile Police Department in the wake of 6 use of force incidents, 4 resulting in death of the suspects, and 2 of which were caught on bystander video that caused a lot of consternation in the community. And because these events happened within a roughly an 8-month time frame, there was a real concern in the community about whether or not there had been a shifting policy or practice or a lack of adherence to training that was causing these incidents. And so the first question was whether or not the use of force was lawful, and then to see whether or not there was some systemic reason that even though these events might have been lawful, there's a phrase lawful but awful. Were there things that could be done that could hopefully prevent the events from happening again in the future?
And one of the reasons I was so intrigued to visit with you about this issue is it struck me you were utilizing a lot of tactics and strategies that we see in the compliance arena. So I wanted to maybe start by asking you, how did you think through the assignment and the structure of what you wanted to do?
That's a great question. So there are law enforcement agencies across the country that are under consent decrees or monitorships by the Department of Justice. And just for some background, when a Department of Justice investigation occurs and a monitorship is imposed, the local authority lose all control over their local police. If they want to change any policy or practice training, they have to first get approval of the monitoring team, and then they have to get approval of the court in order to implement those changes. Then they also have the pleasure of paying about anywhere from $10 to $12 million annually to pay for the activities of the monitoring team being in their city. So it could be a real financial burden for a city to come under a consent decree with the Department of Justice that has to be implemented by a court. So for those proactive jurisdictions, I would say that the constitutional standards, and I'll go over those for in a minute, the constitutional standards that you can set or that are set, you can go above that. And courts have ruled that if you set higher standards than what is constitutionally minimal, you are not held more liable in courts of law if you're sued, if you happen to have a situation where you have to use deadly force. So it's worth it to spend the extra time and looking at your policies, not only what is approved by the state training agency, but also look around at Department of Justice monitorships to make sure that you are really implementing the best policing practices possible in your community so that, God forbid, you can avoid a DOJ monitorship.
I would just add that you should try to avoid a monitorship in every case you're in front of the DOJ on, having been under a monitor. But how could you tell us a little bit about the constitutional standards you mentioned and the minimum standards that and what may go above that?
Yeah, so there are two seminal cases that describe the use of force. And I focus on the use of force, but there are a lot of different components of what could come under the focus of a DOJ investigation, but it tends to be most often the use of force, which is a Fourth Amendment seizure of the highest nature to use force and to use deadly force. Tennessee versus Garner was decided in 1985. And this was a situation where a fleeing suspect was killed by an officer, and the court said, hey, and it was a burglary suspect. I said, you just can't use the fact that you have a fleeing felon suspect to use deadly force. That's an unreasonable use of force. You have to have some suspicion that he is going to use deadly force against you, the officer, or someone else in the community at large before you use that deadly force. In other words, you can't be judge, jury, and executioner of someone just because they've committed a felony, unless you yourself perceive a reasonable law. And then in 1989, you've got another case that was decided, and this case decided that, and it's the Garner case, Connor versus Graham. I'm sorry, Connor versus Graham. And this case decided that a reasonable officer, not looking at the situation 2020, could use reasonable force or use deadly force if they reasonably perceive that the suspect was going to cause great bodily injury or death to themselves or to a bystander or to someone else. And in that situation, deadly force is reasonable. Now, that should be looked at not hindsight 2020, according to the ruling, because officers are forced to make split-second decisions about the use of force, which could or could not cost them their lives. So it's not hindsight 2020. In the moment, what a reasonable officer would do. Now, the reasonable officer component sometimes gets examined by DOJ to say, what training did they have? What training were they provided? And was it reasonable? And of course, we know that more recent developments of this law that came out of the incident in Minneapolis, where you had Derek Chauvin put his knee on the neck of George Floyd. Now officers are even held to a higher standard where they can be personally liable and criminally prosecuted if they, as a bystanding officer, witness someone else, so another officer violating a person's civil rights and they fail to intervene. So now there is a duty to intervene if they witness that type of conduct. Otherwise, they, along with perhaps the deficient training of the police department, can be held personally liable, both civilly and criminally, for a failure to intervene. So this is serious stuff.
You mentioned the community, and I want to expand that to communities. Uh, Obviously, if a corporation gets in trouble, they can be in the front page of the Wall Street Journal. Police department gets in trouble, it's typically a video posted, as you said, perhaps lawful, but certainly awful. How does this type of self-imposed or self-directed review help a police department with the constituent communities in its city or jurisdiction?
In certain communities, there's a distrust for police. Certainly, that is somewhat true among the African American components of communities across the country, where there has been some antagonism and perhaps some abuse that has gone on. And so, if you've got constituency, even if you don't have that diverse constituency, creating transparency where you can demonstrate as a police department that you're able to say, hey, we got this wrong, or hey, here are our policies that guide us. because a lot of police departments don't even have their guiding principles and rules or memorandum orders or general orders published online for the public to see, then there becomes a real credibility problem. And so the first step that most monitors of police departments do, they say, hey, you've got to post your guiding principles online for the public to see, and you've got to integrate the public in the process of setting what your rules and guidelines are. Now, police, of course, they perform a specific role that's unique, and you don't want civilians controlling all of that, but they've got to be part of the process in order to create transparency and trust with the community. Otherwise, you're just engaging in enforcement actions. There's Sir Robert Peel, the originator of policing, said, hey, the people are the police and the police are the people. So you've got to get them integrated into the policing process, or else your criminal justice plan is going to have problems.
I'm not sure I have ever heard on a podcast someone cite an 1830s London police commissioner. Well done. Actually, he was a PM. Well done. Well done. The types of policies and procedures and trainings that you talked about in the corporate world, we would say you develop your policies and procedures, you train on them, you monitor the results, and you improve as appropriate. Is that type of process work in the police department, or do you go to the academy, you're trained, and then you go out and enforce the law?
Yeah, so I think it's a mixture of those things. Certainly, the post in each state, which is the police training certifying entity, has their number of requirements in each state that officers are required to get before they become a police officer and after they become a police officer. So training can take place through a state entity, state training entity, or it can take place at the local academy that's established by the police department. And then it can take place on a daily basis while they're at roll call, where they are given pointers and tips about the different training aspects to be reminded about. But generally speaking, it's about 320 to 800 hours that an officer has to receive nationally in order to carry the badge. And so that may vary from state to state.
The use of force is something you talked about that as a Fourth Amendment violation. Is that the number one issue, or are there other issues that either you were aware of and looked at or came about from your review?
So it really depends on the jurisdiction. For example, Memphis was under a consent decree for many years, and they were engaging in First Amendment violation, where they had people protesting and they were gathering information from their vehicles, trying to identify who they were, and then keeping a database of those individuals, even though they had not formally committed a crime. And the court said, hey, you can't violate a person's right of association or to free speech by collecting information about them and keeping them in the government database. Some police departments have problems with respect to how they interact with the LGBTQ community, or how they deal with persons who have developmental disability, mental health issues, and they don't have adequate training. So any one of those could lead to tragic consequences if the officers don't have adequate training and they don't have adequate policies to address those different issues. So it kind of depends on the jurisdiction, but the point of doing an outside review is to look at what the Department of Justice has done in monitorships across the country and compare that to the policies that the police department has in play already, as well as their training. Because DOJ, if they come in, they're going to look at your policies, they're going to look at your trainings, and then they're going to look at the videos of people or officers actually on the street enforcing the laws to see if there's space or a gap between what their policy is, what their trainings are, and what the officers are actually doing on the street.
Kenyon, did your review show that certain actions or even language can escalate a situation, perhaps beyond reasonableness? Or the flip side, were you able to point to areas where police officers de-escalated situation through certain strategies?
Right. So that's a great question. And again, I go back to the model monitorships. All of them require that officers receive training and de-escalation tactics. Some of them require that officers do not have to hold their ground. They can kind of retreat to a safe spot rather than the deadly force if possible. And so what we did was say, look, there in certain circumstances, the use of force, deadly force, was, according to the law, reasonable, but were there things that could be done to make it avoidable? And I'll point out one thing, and that was the use of a SWAT team, and which is the most aggressive tool that a law enforcement PD can use. And using that early morning or using that without really also evaluating not only the threat to officers, but also the threat of death to suspects in that situation. So in two of the cases that I reviewed, there was a form that the police department used on whether or not to activate the SWAT. And based upon the answers to questions which were weighted, the use of the SWAT was either not necessary, optional, or mandatory. In one of the cases, it was optional, but because there was a manpower shortage in the narcotics unit, the decision was made at the lieutenant level to use the SWAT and then use it early morning. There was only one question on this form that kind of related to citizen safety or suspect safety. And it said, are there any elderly, handicapped, or children, juveniles in the home? But under it, in parentheticals, it had for informational purposes only. And to the side, in the yes or no column, where you could answer all the other questions, yes or no, was permanently blacked out. So it really gave the impression, at least to a reviewer, absent any other document that might say they looked at these factors otherwise, it appeared that there was not a genuine look at whether or not the use of the SWAT team could cause death or bodily injury to the citizenry. And so that's the type of thing where a person like myself said, look, you could have prioritized the sanctity of life by doing a genuine examination of whether or not you could do the raid in the afternoon when the kids aren't at home, rather they would be in school. Because of one case, a 16-year-old juvenile armed himself after the police stormed in, and they used deadly force on him appropriately under the law. But if they had made the decision to do it in the afternoon, he would have been in school, and he wasn't the person they were looking for anyway. So it's situations like that that DOJ would look at, that I tried to look at. Are there policies that you can put in place as a police department that would prioritize the sanctity of life, that would protect the citizens more, as well as continue the protection of the officer?
Kenyon, what did you find in terms of the issue of civilian leadership over the police leadership itself, whether commissioner or whatever the structure might be, and culture within the organization? How do those three really interrelate?
So I apologize because I don't think I answered your past question before. You asked about escalating factors, and police culture has to be closely monitored because you have to remember these are the only people in our society that have the legal right to, and their discretion, seize property, person, and life. And they both do a wonderful job doing it, but a lot of police departments have very young police officers who may not have the wisdom one would hope or the experienced one would hope and execute their responsibility. And that's why the command staff of the police department has to be really sophisticated and convincing in exercising those duties in a responsible way. And so to the extent, like, for example, officers use profane language towards citizens is very important. If there is profanity that permeates citizen interactions, one, it disrespects and takes away dignity from the citizens and they lose credibility in the community, but it also creates a mindset where the police department officials, and not to say all officers, but it could for some, particularly those young and impressionable officers, make them think that they can overstep their bounds as they disrespect public. So a command staff or a chief of police really has to take a hard line against the use of profane language. And you have to train people to say, look, this is just not acceptable. And it's the Bible puts it this way: it's the little foxes that ruin the vineyard. And while the use of profanity doesn't seem like that big of a deal, it really is a big deal in terms of officer interaction with the public because it is an escalating factor in the use of force. And so when you see the use of profanity, you will see a corresponding need to use force by the officer because the person that they encounter and use that bad language on is going to respond accordingly. And you might say officers face that bad language all the time. They're just people. That's why they're trained. That's why you put them through training so that they can learn how to ignore certain activities. And rather than do their instinct, they respond instinctively based upon the training that they've received.
Let me turn to some questions around leadership because I think everyone recognizes we need civilian leadership over a police department, whether that be a mayor, or be a county official, whoever that might be. But we also have obviously police leadership, whether it be police commissioner, chief of police, whatever the title might be. What is the interaction of those two and their joint role in creating culture?
Yeah, so many cities nowadays have what's called a public safety director, but ultimately the person that's in charge of the police department or responsible is the mayor of a city. And so typically you'll have a mayor, you might have a chief of staff, then a public safety director, then a police chief, assistant chief, and then majors kind of set out. And it may vary somewhat from police jurisdiction to police jurisdiction. But you absolutely have to have that civilian control of the police department. Again, because they're the only people empowered in our country to use and seize force or use force, including the use of deadly force, in order to enforce the law within their discretion. And so if you don't have civilian bounds kind of directing that, then things can get out of control. And I don't think that there's really a police department in America that successfully run. They don't have great civilian oversight.
Kenyon, one of the issues I wanted to ask you that if it came up was the issue of no-knock warrants. And they've been criticized in some jurisdictions, leading to some deadly consequences. Other jurisdictions are more comfortable with them. Was that something that you at least looked at in your review?
I did. There was, and I'm going to draw a slight distinction. So no knock warrants, generally when police departments get warrants, they can execute it at any time, a search warrant for a home. And no knock warrants are a little bit heightened on that approval process. And this would include just kind of busting into a home and then announcing the fact that police or the entity or the person's entering the home. What I had was close to a no knock warrant where it's called a knock and announce. So it's a quick knock on the door, police, and then police use dynamic entry or explosives on the front door, perhaps a side door, in order to immediately enter the home. And the point of those is to disarm the inhabitants of the home so that they don't have a chance to really react and defend themselves and just will surrender automatically. Tom, are you still there?
Still there?
Okay, I computer was trying to do the automatic updates. So my apologies. So,
No problem.
so, so what will happen there is that people, or the citizens, complain that, hey, we don't know who's entering the house. We often are confused, disoriented, and we don't often hear that it's the police. And so people, of course, they're in their homes, many of them have arms, and they arm themselves, and then they get shot by police. So no-knock warrants are incredibly, one, dangerous for officers and the citizenry, but are necessary in high-risk situations, of course, but I think should be thoroughly scrutinized within the police department and require the approval of a chief rather than even a major or something like that.
Kenyon, I wanted to end by asking you the review that you did and the work you did with the Mobile Police Department. Is this a model that other police departments can utilize before incidents of deadly force come to the public eye, before the federal government comes down, and really use it as a proactive, independent, third party oversight to help the police department, to help with community relations, and help to give us better law enforcement?
I think the answer is yes on all points you just raised. And you want your police department to be proactive and looking at the best standards that the Department of Justice has implemented in the 14 or 15 consent decrees they've had across the country, I think can really open your eyes to practices that you can improve upon. I mean, nobody likes anybody else in their kitchen telling them what to do, for sure. But if you can have someone come in on a third party basis, keep control of your local police department and not pay that 10 to $12 million a year for a federal monitorship, then I think you're doing a lot. And I think it also helps law enforcement officers do their jobs in a better way, where they have transparency and trust with the community that they otherwise might not have. So they need to re-examine those general orders, those memorandum orders, those guiding principles that help them execute their jobs every day, and have someone look at those and say, look, this is a decent policy, but you can do better. Or I see that you have a duty to intervene, but you really don't break down what that requires of the officer on the scene. So yes, to all of your question.
Kenyon, unfortunately, we are near the end of our time for this episode, but before we leave, I wanted to ask you, could you tell our listeners your new firm, the new firm's website, and if they wanted to connect with you, what might be the best way to do so?
Sure. They're welcome to give me a call, 2-585-6907. Again, that's 202-585-6907. And I'm with the Thompson Coburn Law Firm in Washington, D.C. Thompson Coburn.
Kenyon, I wanted to thank you again for reaching out. This has been a great way for us to catch up. The topic you talked about is one that's incredibly important, and I hope we can have the chance to visit about it in the future.
Thanks so much, Tom.